let's look now at the other big protection that we have, the Due Process Clause, right, in the 14th Amendment of the Constitution. Courts recognize two kinds of due process protections, procedural and substantive. Procedural due process can come into play for people with disabilities whenever they're subject to some sort of an official process that's going to be taking away their rights, like guardianship or civil commitment. Procedural due process demands that the procedures by which those rights are taken away comply with procedures that we generally require for all kinds of proceedings, like criminal proceedings. They have to be fair. They have to be impartial. If fundamental rights are going to be taken away from you, you have to be told that that's a possibility before you start the proceeding. You might have the right to assistance of an attorney. You have the right to an impartial judge. You have the right maybe to present evidence, those sorts of things. Those are all important protections that the Constitution gives people with developmental disabilities in any proceeding in which any of their rights might be taken away. The other kind of due process that's protected under the 14th Amendment is substantive due process, and that protects us more generally from anything that a government might do that might deprive us of life, liberty, or property without due process of the law. And that can be used to challenge laws that might deprive a person of a disability of fundamental rights, just like the Equal Protection Clause. Some examples: voting. Voting has been held to be a very important fundamental liberty interest, and it's subject to the limitations of the Due Process Clause. You can't take it away from somebody unless you can justify the reasons for doing so, and those reasons meet the standards that courts have established for taking away those rights. Another big example, institutionalization. Clearly, right, is a major deprivation of liberty across the scale. And there are a number of the large wave of cases that led to the deinstitutionalization of many, many people with developmental disabilities and other sorts of disabilities in this country were done through means of arguments about the violation of the Due Process Clause. One of the big Supreme Court cases was in 1982, not that long ago, right? Youngberg v. Romeo, in which the Supreme Court interpreted the due process obligations of states with regard to people who were involuntarily committed in state institutions on account of a mental retardation. The court said, if you are going to be taking away the liberties of those people, you have an obligation, state, to provide adequate food, shelter, clothing, medical care, and reasonable safety under the due process provisions of the Constitution. They also held that restraints can't be used unless you make a professional judgment that they're necessary. So states can't deprive people of more liberty inside an institution just because they're in an institution than they can justify. The government also, the court said, has a duty to provide training and habilitation to the extent that it's necessary. So you can't just warehouse people in institutions because that's the cheapest way to take care of them. Those are constitutional duties under the Due Process Clause of the Constitutional that protect people with developmental disabilities in institutions. We had lots of big cases on state levels then, individual cases in which state actions were taken, and all kinds of levels of courts all across the nation used the Due Process Clause of the federal Constitution to hold that the same sorts of obligations apply to states if they are going to be institutionalizing people. In Minnesota, there's a big set of a whole series of cases that were brought against mental or institutions that housed people with developmental disabilities in Cambridge and in other places. A whole series of cases called the Welch v. Litkins cases, in which the court held that the people who are institutionalized in state institutions for mental retardation without consent, they have a federal constitutional right to treatment. They have a constitutional right to have the benefit of the least restrictive possible environment within that institution, and they're constitutionally entitled not to be subject to cruel and unusual punishment under the Eighth Amendment by means of unreasonable kinds of restraints, even if they are institutionalized. Those are all the types of major kinds of constitutional protections that people with developmental disabilities have been benefiting from. These are protections that they have under their Constitution that we're beginning to recognize as we recognize the fundamental rights of people with disabilities to be treated in ways that are in conformance with our Constitution.